Hello all, welcome to GetintoIAS, and in this video we are going to deal with the chapter Acts and Policies presented by me, Shifnas. So the first thing is the National Green Tribunal Act. So we are going to deal with National Green Tribunal Act, Coastal Regulation Zones, Scheduled Tribes and Other Forest Dwellers Act and Biodiversity Act. So these are the important acts and we are going to deal everything related to the current affairs. So the first thing is the National Green Tribunal Act. So this is a statutory body that is brought about under the law, established under the National Green Tribunal Act of 2010. So the National Green Tribunal was brought under the National Green Tribunal Act of 2010. And then the NGT, that is the National Green Tribunal, was set up to reduce the burden of the courts and for the speedy environmental justice. So it has two main objectives, that is to reduce the burden of the courts and speedy environmental justice. So since they are giving justice, it should be comprising of experts panel. First thing, it deals with the cases of environmental protection and conservation of forest. So what this NGT deals with is, it deals with the environmental protection, the first thing, and the second thing is conservation of forest. So these are the two cases that NGT deals with. Second thing is the enforcement of legal right. They enforce the legal right. And the third thing is relief and compensation for damages to persons or property. If there is any damage to any person or their property, the NGT will give the relief compensation. So these are the key points to be remembered under the NGT. And then moving to the jurisdiction of the NGT. So where and all does the NGT apply? So the rules of NGT, where and all does it apply? So it applies to the Water Act of 1974, Air Act of 1981, Forest Conservation Act of 1980, Environmental Protection Act of 1986, the Biodiversity Act of 2002, and lastly, the Public Liability Insurance Act of 1991. This is very, very important because this Public Liability Insurance Act of 1991 provides, that is, it pays of compensation to victims of industrial disaster. So if there is any industrial disaster that is happening, it pays compensation to the victims. So these are the acts under the jurisdiction of NGT. Now coming to the composition, appointment and tenure of NGT. These three parts are very, very important. So the first thing is composition. So the NGT composes of a chairperson and then maximum 20 judicial members and then maximum 20 expert members. So it composes of a chairperson, maximum 20 judicial members and maximum 20 expert members. So the chairperson and the maximum 20 judicial members should be from the Supreme Court. That is, it should be the judge of the Supreme Court or the Chief Justice of the High Court. So the chairperson and the 20 judicial members should be either the judge of the Supreme Court or the Chief Justice of the High Court. So this point has to be noted down. And then appointment. Who are appointing these people? So the chairperson, right? We saw here the chairperson, right? This chairperson is appointed by the central government in consultation with the Chief Justice of India. So the Chief Justice of India is consulted first and then the central government appoints a chairperson. Then what about the other members? That is all other members. These all members are also appointed by the central government but by the recommendation of the selection committee constituted by the central government. That is, the central government will appoint a selection committee. This selection committee will recommend who and all should constitute the other members, that is the other judicial members and the expert members. So this is the point under appointment. Next, moving to the tenure. So for all of them, the tenure is 5 years and they are not eligible for reappointment. Very, very important point. If they work for 5 years, again they are not eligible for appointment. So reappointment concept is not there in National Green Tribunal. So this is the important key points to be taken from the National Green Tribunal. So we're done with National Green Tribunal. Next, let's move to the coastal regulation zones. So now moving to the coastal regulation zones. So under the coastal regulation zone, we have the coastal area to be like this. That is, there is a low tide line over here and there is a high tide line. High tide line is denoted when there is a spring tide. Spring tide occurs after a new moon or a full moon day. On that time, the tide level will go high and that denotes the high tide line. and over here you have the low tide line, that is the water level will be low over here, and between these two areas you have the intermediate zone or the intertidal zone. So accordingly, the coastal regulation zones was denoted in order to restrict the development activities from the high tide line, that is 500 meters from the high tide line towards the land. That is, if this is the high tide line, from here 500 meters is taken into account and denoted as the coastal regulation zones. So under the coastal regulation zones you have 4 categories, category 1, 2, 3 and 4. Under category 1 you have the eco-sensitive zones, under category 2 you have the urban areas, under category 3 you have the rural areas, and under the category 4 you have the island areas, that is Andaman and Nicobar, Lakshadweep Islands and the islands that are present near the coastal regions. So this is the brief explanation about coastal regulation zone. And then coming to the features of 2018, so totally we had 2000 coastal regulation zone norms, and now we have the revised edition of 2018 norms. So what is the difference between 2011 and 2018? Under this, the floor space ratio or the floor area ratio is noted down. So the CRZ2 areas, that is the urban area, one is for eco-sensitive, CRZ2 category 2 is for urban areas. So under urban areas you have the floor space ratio. This floor space ratio was frozen in 2011 notification, but now it is defrosted under the 2018 notification. Why it has been defrozen is because for building the new buildings in the CRZ urban areas, that is the CRZ2 urban areas. So this is the difference between notification 11 and notification 2018. And then coming to the second change, the CRZ3 areas. So the CRZ3 areas is for the rural areas. It is divided into two, that is the CRZ3A and the CRZ3B. So what is the difference between CRZ3A and CRZ3B? So the density of population, that is this area 3A, it is densely populated, but this area 3B, it is relatively densely populated when you compare it with the CRZ3A. Approximately the population should be 2161 per square kilometer, and the population in the CRZ3B area is less than 2161 persons per square kilometer according to the 2011 census. So what has been changed in the CRZ3A? So normally I told you all about the high tide line. From this high tide line there is a zone called as the no development zone where you shouldn't do any activities. So in that area, in that no development zone, previously in the 2011 norms it was up to 200 meters, but now in 2018 it has been revised and decreased to 50 meters. So the no development zone is only 50 meters from the high tide line. But then in the CRZ3B area it is the same. It has been maintained up to 200 meters from the high tide line. So this is the second change brought about. So firstly, the floor space area was defroze in order to build new buildings in that area. Secondly, the CRZ3A and CRZ3B, only the 3A from 200 meters to 50 meters it was reduced. And then the thirdly, the tourism. So the shacks, toilet and changing rooms in beaches is to be established. So normally already the toilets was present in the beaches. Now all the shacks, toilets and changing rooms is to be established. But there is one such restriction in the 2018 norms, that is from the high tide line this 10 meters should be maintained. That is within the 10 meters you shouldn't build any shacks, toilets or changing rooms. After the 10 meter only you should build the toilets or changing rooms. And then next, moving to the permission, the projects under CRZ1 and CRZ4 will be dealt by the Ministry of Environment, Forest and Climate Change for clearance. That is basically by the central government. So the central government will regulate all the projects relating to CRZ1, that is the eco-sensitive zone, and the CRZ2, that is the island zone. And in the CRZ2 area and the CRZ3 area, the state government will deal with all the projects. So this is the new change brought about in the 2018 notification. Previously, all the projects under category 1, 2, 3 and 4 was dealt by the central government. Now only 2 and 3 is dealt by the state government, and 1 and 4 is regulated by the central government. And then moving to the fifth point, the no development zone in islands is to be 20 meters. We already saw in the CRZ 3 area, the no development zone is 50 meters, and in the rural areas it was 200 meters. But now coming to the islands, that is CRZ 4 area, the no development zone is 20 meters only. And then coming to the ecologically sensitive areas, it is given special attention or special importance. And then coming to the last point on the CRZ notification, the pollution abatement is seriously calculated in the CRZ 1 areas, because those are very ecologically sensitive areas and various treatment plants has to be set up in that area for the pollution abatement. So these are the important points to be noted down under the CRZ regulations, that is the coastal regulation zones. So we already saw about the coastal regulation zone. So under the coastal regulation zone, there were two kinds of notification, that is the 2011 notification and the upgraded 2018 notification. So this 2011 notification had a lot of constraints, but the 2018 notification relaxed most of the norms. So then what is the coastal regulation zone? So there are two types of tide lines. This is the high tide line and this is the low tide line. You can see this area of high tide line. So this high tide line happens when there is a spring tide. So there are two types of tides, right? One is the neap tide and the spring tide. So the spring tide will occur after a new or a full moon. So after a new or a full moon, there is a high tide called as the spring tide. So when the water reaches to this level, this area will be on the top. This is called as high tide line. And this shoreline where the water recedes back, that is the low water level, is called as low tide line. And the region in between or the zone in between is called as the intermediate zone. So this intertidal zone or the intermediate zone is present in between the high tide line and the low tide line. And then what is happening is, for regulating the development activity, what is a coastal regulation zone is? For regulating the development activities of the coastal zones within 500 meters of high tide line on the landward side is classified into 4 categories. For example, I said you all, this is the high tide line. So from this high tide line, go inside the land 500 meters. If you go inside the land, this area is regulated very well and it's called as the coastal regulation zone. So from here up to 500 meters, you have the coastal regulated zone, or the development activities is controlled within that area. So it is classified into 4 categories, right? Category 1, 2, 3 and 4. So under category 1, you have the eco-sensitive zone, and under category 2, that is eco-sensitive zones like national parks, wildlife sanctuaries. So under category 2 or the coastal regulation zone 2, you have the areas near the shoreline. That is mostly the urban municipal areas. And under the coastal regulation zone 3, you have the undisturbed area and the rural areas and the urban areas that are not developed. So under category 3, you have all these areas. So what will come under the coastal regulation zone category 4? So the Andaman and Nicobar Islands, Lakshadweep and the other small islands constitute the coastal regulation zone 4. So we saw what is a coastal regulation zone, why we need a coastal regulation zone, and the 4 types of coastal regulation zones. Now coming to the notification changes. So previously the 2011 notification was revised in the 2018. So firstly, the Ministry of Environment, Forest and Climate Change notified the coastal regulation zone in 1991. So the coastal regulation zone notification was let in 1991 and it was revised in 2011 by the Shailesh Nayak committee. So Dr. Shailesh was the head of the Shailesh Nayak committee on regarding the concerns of the coastal areas and the union territories. So the coastal areas and the union territories were taken into account under the Shailesh Nayak committee and the coastal regulation zones was framed. That is, the revised notification of 2011 was framed. And then what happened? The recommendation for the coastal regulation zone was let in 2015. That is, the Shailesh Nayak committee's recommendation was submitted in 2015 and approved in 2018. That's why the revised notification came in 2018. So what is the revised notification, or what is the difference between 2011 and 2018? So there was a line called as the hazard line in 2011 notification. This was now changed to fixed setback line. So the hazard line is now changed to fixed setback line. So what earlier happened was in 2011 they notified the hazard line after the 2004 tsunami. So the 2004 tsunami was kept in mind and the 2011 notification was let out, and in that we had the hazard line. So according to that, to prevent the degradation of coastal ecosystem, this hazard line was notified. And then in the hazard line, the tides, the waves, the sea level rise, the shoreline changes was surveyed. So all these things was surveyed, that is the tides, the waves, the sea level rise and the shoreline changes was surveyed first of all, and the hazard line was comprised for the macro and micro planning and the land use in the coastal area. So why was this hazard line constituted? Because to plan up with the macro and micro conditions in the coastal area and the land use pattern in the coastal area. So all these was constituted under the hazard line. So they changed it to fixed setback line in 2018. So what is a fixed setback line? Under this, till 500 meters from the high tide line on the seafront or the beach. So under this, we already saw till 500 meters we had the CRZ, and then till 50 meters of high tide line from the rivers. So if it is a beach, the coastal regulation zone or the fixed setback line was 500 meters, and for the rivers it is 50 meters from the high tide line. So according to the CRZ notification 2018, we are seeing that it relaxed restrictions and permits construction. So this is really not good for the coastal ecosystem. So it relaxes what? Restrictions and permits construction. So according to the Coastal Regulation Zone 2018, it relaxed restrictions and permits construction. So what does it do? It relaxes restriction and permits construction in the urban coastal regulated zones and the densely populated rural coastal areas. So right in the urban coastal regulated zones and in the rural coastal areas, the relaxation was done. So what are the impacts of relaxing all these coastal regulated zones? First one is the high coastal tourism. So they relaxed restrictions, right? So that paved way for the tourism, that is the coastal tourism. That shrinks in all the lagoons. So high tourism is really not good for the lagoons. And then construction near the sea is of a huge risk because of the increasing sea level. And then frequent cyclones are omitted. So in these revised notification, that is, it relaxed restriction and permitted constructions, right? So when there is a cyclone, they really didn't take into account the impacts of the cyclones. So all these are the impacts due to the Coastal Regulation Zone 2018 relaxation. And lastly, the illegal sand mining, right, erodes the shoreline. So because of the construction activities permitted near the Coastal Regulation Zone, the illegal sand mining will happen in a large extent and that will erode the shorelines. So next, now moving to the Scheduled Tribes and Other Dwellers Act of 2016. So what is the Scheduled Tribes and Other Dwellers Act of 2016? So these scheduled tribes and the other forest dwellers are considered to be the vulnerable sections. So under this, the aims of the act includes to recognize the forest rights and occupation of these people, that is the scheduled tribe people and the forest dwellers. That is, you should recognize their rights and their occupation. Next thing is to form a framework to record the forest rights by evidence. So for generation and generation, these people live in that area and each one of the community have a special occupation. So by evidence, you should note down all their rights in a framework. And then you give the rights to the scheduled tribes and the other forest dwellers, that is the responsibility for sustainable use, conservation of biodiversity and maintenance of ecological balance. So once you recognize the rights of the scheduled tribes and other forest dwellers, you tell them, you give them the responsibility to the sustainable use of the products, the conservation of biodiversity in that place and maintenance of the ecological balance inside the forest. And then the livelihood and food security for them should also be taken care of. So these are the aims of the Scheduled Tribes and Other Dwellers Act of 2006. So then, who has the authority to vest the forest right? So we are talking about forest right for the scheduled tribes and the other forest dwellers, right? So who has the authority to vest the forest right? That is to give the forest rights to these people. That is the Gram Sabha. So Gram Sabha has the authority. So the Gram Sabha will initiate the process of forest rights within the local limits. First of all, they will initiate. The first process is to initiate the process of forest right within their limit, and then the same Gram Sabha should pass a resolution. So they should pass a resolution, and that resolution is forwarded to the subdivisional level committee. So the resolution passed by the Gram Sabha is then forwarded to the subdivisional level committee. This committee is set up by the state government. So it is set up by the state government, and what it will do, this committee will examine all the framework under the Scheduled Tribes and Other Dwellers Act, and then it will prepare a record of forest right. So you want forest right for the scheduled tribes and the other forest dwellers, right? So once when this framework or the resolution is examined, it will prepare a record of forest rights for these people. So these are the key takeaways under the Scheduled Tribes and Other Dwellers Act. So now moving to the last topic under the acts and policies, we have the Biodiversity Act of 2002. So under this, the UN's initiative, the United Nations initiative, that is the Convention on Biological Diversity, called as CBD. We already dealt with the CBD, that is the Convention on Biological Diversity. So why do we need CBD? It is for protecting the biodiversity and sustainable use of natural resources. This is why the CBD was brought in under the UN's initiative, and then India is a signatory to the CBD, that is the Convention on Biological Diversity. So then what happened was, earlier the Parliament passed the Biological Diversity Act of 2002 to protect the biodiversity. Since India is a signatory to the CBD, India brought the Biological Diversity Act of 2002. So what are the features of the Biodiversity Act of 2002? Under this, to conserve the biological diversity. So what is a biological diversity? It is the variation or the variety in the plants and animal species inside a specified area, and then the sustainable use of any product or resources. That is, our present generation and our future generation should also use the products or resources present in our environment. So we shouldn't deplete all the sources. That is called as sustainable use. And then fair and equitable sharing of benefits arising from it. So if any benefit is arising from one country, you should share all the benefits with the other country. So this is the features of the Biodiversity Act of 2002. And then coming to the setup of the Biodiversity Act of 2002, there are two setups. First one is the National Biodiversity Authority, NBA, and the State Biodiversity Boards, SBB. So this NBA is very, very important. So what does the NBA denote? So it is a statutory brought out under the law and the autonomous body, that is, it is not dependent on any other body, it is independent and makes its own decision, and the headquarters of the NBA, that is the National Biodiversity Authority, is in Chennai. And then it is established under the Ministry of Environment and Forest in 2003. So it was established in 2003 by the Ministry of Environment and Forest. And then who are the members of the NBA? So the members of the NBA will comprise experience in the field of environment and the members of the various government ministries related to environment. And then the third point is they implement the provisions under this act. That is, all the members, right? All the members here, they implement all the provisions under the Biodiversity Act of 2002. So what are the functions of the NBA? The functions of the NBA, first one is to advise the government on conservation of biodiversity. Second one is the foreign national required approval from NBA for obtaining biological resource. For example, if USA wants any biological resource from India, it needs to get approval from the National Biodiversity Authority. And the same way, Indians should seek approval from NBA before transferring research materials. That is, if India is seeding away any material in from here to USA, it needs to get the approval of the NBA. And lastly, what are the penalties under the Biodiversity Act? First one is, if you cross any rules or regulation provided under the Biodiversity Act, first one, you get an imprisonment of 5 years and the fine will go up to 10 lakhs. So these are the key points to be noted down under the Biodiversity Act. So we have done with the Biodiversity Act under the lesson Acts and Policies. Thank you for watching. Meet you in our next video. Please subscribe.